Okay. Well, I just thought we had a meeting. Well, good morning, at least from Canada. I think there might be people in different times of the day throughout the world, but it's morning here in Canada. So good morning to everyone. Um, we actually had a smaller group meeting with Hannah, Alyssa, a couple of weeks ago, where we tried to think of some topics that we think might be useful in the context of this meeting and frankly the global context that we're living in now. Over the last month, there obviously has been quite a tumultuous time that people have been living through, and so we thought of a couple of topics that we think might be of interest. One of which is, I guess, increasing trends throughout the world towards greater corporate transparency, um, and not just corporate transparency, but transparency affecting other types of business vehicles, including trusts, including partnerships, and other types of business vehicles. So I know certainly from the perspective of corporate transparency, there has been a trend over the last 3 or 4 years through various international organizations to come up with general standards for corporate transparency. One of the things that has been pushed forward as a policy matter throughout the world and throughout many jurisdictions is the requirement that companies, so corporations, keep internal registries of beneficial owners. And I think we had touched on this topic maybe about a year ago, very briefly during one of our discussions, but we thought it might be a good opportunity to revisit that and discuss whether there had been any additional trends in that respect throughout our various jurisdictions. So for those of you who may or may not be familiar, but there are requirements in a number of jurisdictions, as I mentioned, that corporations maintain these registries of beneficial owners. And the idea there is to not just look at the direct shareholder of a particular corporation, but actually try to see whether or not we can identify the ultimate individuals up the chain who is the beneficial owner of whatever economic interest is deemed to be the appropriate threshold. I think through many in many jurisdictions, the appropriate threshold is considered to be 25%. So 25% is considered to be a threshold at which a person has rather significant control over a corporation, or at least significant influence, if not actual legal control. And so certainly from speaking from the perspective of Canada, we've got all of our jurisdictions in Canada, both the federal government and the provincial governments throughout Canada, which have jurisdiction over corporate law, have all agreed to implement this type of registry, a registry of ultimate beneficial owners. And the same thing happens in other jurisdictions as well. I know the European Union has similar requirements for each of its member states. The United Kingdom as well. I'm sure as well that there are jurisdictions outside the EU and other parts of the world that do have similar rules. One of the important, interesting trends, though, and this is the main topic that I'd like to hear some feedback on from others, is whether or not in your jurisdictions these registries of ultimate beneficial owners are public, because that is a trend that we're starting to see in Canada. A number of both our federal government and one of our larger subnational governments, the government in Quebec, the French-speaking province in Canada, have now implemented rules that actually make these registries publicly searchable. So you can actually go onto a government website and search by an individual's name and find out where he or she, which entities he or she is is an ultimate beneficial owner of, and that's caused some controversy, internally in Canada as to whether or not this is a violation of a person's privacy, or whether or not there are some broader public policy considerations that make it worthwhile to actually have almost an exception to the general rule on privacy. And so I was curious to know whether in other jurisdictions that trend is being followed through on as well. And I know that there have been a few people joining, so good morning to everyone there. Ian.
Good morning, welcome. We've got a few folks coming in late.
That's okay. Yep. So we were just talking
anyone?
about. I don't know if anyone
Go
has
ahead.
any feedback or initial thoughts. I can also talk about other elements of transparency in Canada, uh, including recent rules that are actually similar to the corporate transparency rules, but that apply to partnerships and trusts. So in addition to corporate transparency rules, we've got an increasing trend in Canada to require the disclosure and ultimately the public disclosure of beneficiaries of trusts. Which again causes some level of controversy and some level of discussion amongst practitioners and amongst policymakers as to whether or not this is an appropriate trend given privacy concerns for individuals.
Yeah, hi, John. Hi, everyone. Irene here from Malaysia. Yeah, I think that's also the trend in Malaysia. What I know, and I'm actually not a corporate lawyer. I'm a tax lawyer, but I did hear from my corporate colleagues that for companies incorporated in Malaysia, there's now this requirement to disclose beneficial ownership. I'm not sure to which level, whether it's the immediate or beyond that, but that seems to be a requirement now.
And are there any, thank you, Irene, are there any requirements for other types of business vehicles, such as trusts, commercial trusts, or even personal trust, do you know, or is that?
No, I think normally trust in Malaysia, it's not even required to be registered unless you want to have an incorporated trust. And we also have, you may know about the Labuan tax regime, which is a separate, Labuan is an island in East Malaysia, and it's got a preferential tax regime. And one of the attractions of Labuan is the secrecy provisions or the confidentiality provisions. I'm not sure whether it's hit Labuan yet, but I think it's not in the law for Labuan, whereas in the other domestic companies, it might be a legal requirement to disclose.
Okay, thank you.
So I'm happy to go. We do have significant beneficial ownership requirements in India. And these typically apply at a much lower threshold than what you mentioned, John. So for us, it's a 10% on a look-through basis. And that's 10% of ownership in shares or 10% of voting rights. So we look at title as well as the control of those shares. Where we have seen some issues, and the rules are fairly recent, they're about 2 or 3 years old, is that when we look through the ownership structure, if there are intermediary entities, so if there are partnerships or trusts or so on, the rules do deal with how the look-through will be applied. And they're not always consistent in terms of how you should apply a look-through. So for example, for trusts, what they say is that for a revocable trust, the settlor will be the beneficial owner. But for irrevocable trusts, which are discretionary, it will be the trustee which will be the beneficial owner. And for determinate trusts, it will be the beneficiaries who are the beneficial owners. So if you have a situation where it's a revocable determinate trust, for example, you could potentially end up with multiple beneficial owners based on how the regulations are written. There's also, because they apply dual conditions of voting and title, the ownership, we do sometimes see situations where multiple beneficial owners come up because of the way in which companies have been structured. So although in theory we do have all of these rules and we're trying to apply a look through, I think driven by transparency considerations similar to what we're seeing around the world, in practice we do see some amount of back and forth, if I could call it that, in terms of how these standards are being interpreted at the ground level. So for example, if trusts have a corporate trustee in place, so if it's a bank or a financial institution, for example, even though they are trustees, they typically take the position that they don't need to disclose themselves as beneficial owners, because they say that it doesn't make sense for a financial institution to be a beneficial owner for all of these trusts. And so in practice, they never file, even though the law says that the trustee of a discretionary trust is essentially the beneficial owner. We do expect that these issues should be ironed out in the next few years, but at this point, we still see a lot of back and forth, at least in situations where the ownership and control are not tied together in the hands of one individual, and particularly if there are intermediary entities which hold stakes in these vehicles. Our registries are not public yet. So although the immediate shareholding is publicly searchable, the beneficial ownership is not publicly searchable at this point. Privacy is a fundamental right under Indian law. So our Supreme Court in a 9-judge judgment reiterated this very strongly a couple of years ago. So I would expect that if we do have provisions that are put in place that make these directories publicly disclosable, then that would potentially be subject to a challenge under our constitution.
Okay, interesting. Yeah, and it sounds very similar. Aside from the threshold, I think the other rules seem quite similar, particularly as they apply to looking through entities, intermediate entities that themselves might have some obscure or some level of obscurity when it comes to figuring out who the owners are, and we actually don't have very detailed rules with respect to trusts. That's something that unfortunately the government has not provided detailed rules for, aside from the basic definitions, and the basic definitions themselves actually don't lead to or lead themselves to some bit of controversy. So I'm actually quite interested in seeing the particular regulations that you refer to, and perhaps that's something that our governments will eventually adopt. You mentioned that there's, okay, so that's interesting that there's no public disclosure in India. I suppose it's the same privacy concerns would be the case here. I think a lot of the fundamental concerns are the same, but is it possible under Indian law to actually have an explicit exception if the law explicitly says that it overrides policy concerns? Is that something that's possible under Indian law, or is it baked into the constitution?
So at this point in time, privacy has been recognized as a part of the fundamental right to life under the Constitution.
Okay.
It's not a legislated rule. It's been an interpreted rule. And so if we try to make exceptions to it, you would need to go to the court and explain to the court as to why it's an exception to the fundamental right. We do have situations in security type contexts where that exception has been recognized, but where context is not sure at this point in time. I think it would have to be tested before a court.
Okay, interesting. And maybe one last question before we go to other, is there any when it comes to disclosure in the public corporation context? So I know in Canada we've actually got some specific rules that exclude public companies in some circumstances from having to fill out or actually having to maintain a registry, because they obviously have it's a public company, so the considerations are different. But there are public companies in Canada that are majority owned by, say, closely held families that own a big block of shares or multiple voting right shares. Are there any requirements in India vis-a-vis public companies that might be interesting?
That's actually a good question. I don't know the response to that offhand. I think the way it's been applied is that it's generally control that has been looked at. And so in a public company context where control tends to be more staggered, that's probably where you get away from disclosure related requirements, but I would need to cross-check that.
Okay, perfect. I just wanted to double check. Well, thanks so much. I appreciate that insight. I don't know if anyone else has...
I think here in the Philippines, I could share our experience. So we do have just lately these corporate transparency regulations issued by our Philippine Securities and Exchange Commission. So they were issued via a memorandum circular. There are reportorial requirements basically on the corporation as well as on the director. So the way they did this was that the corporation, which is required in any event to submit this on an annual basis at the very least, a general information statement, now has to indicate in this general information statement its ultimate beneficial owner. And the threshold that they are looking at there is, I think, similar to yours, John. It's also 25%. So they have like a set of rules on who the ultimate controlling entity will be considered following certain rules. So now the GIS has to include that. But on top of that, a director who's a nominee of someone else needs also to disclose to the Securities and Exchange Commission who the principal is. So if, let's say, I'm a nominee director, I have to tell the SEC that my principal is, let's say, another corporation. And if that corporation is not a Philippine corporation, then I have to also state the ultimate controlling entity. So it's twofold. It's now imposed on the corporation as well as on the individual, and there are certain penalties actually imposed of you for non-compliance. And all of these rules came out when we were still, well, shortly before the pandemic and even during the pandemic. So since most law firms actually act as nominees or act as corporate secretaries of corporations, we were really we had to do a lot of work even during the pandemic to be able to comply with these requirements. Now, to your question on whether this is searchable, there are certain pages of our general information. Everything is actually submitted to the SEC, but whether or not it could be publicly searched is it's a different question, because even with our general information statement, certain portions of it are actually not uploaded for or available for public search because of concerns with data privacy. So I mean, that's the state of that's where we are right now. So if you're a corporate secretary of a corporation or a resident agent, let's say of a Philippine branch, then you have to comply with all of these requirements. Now, if you're a nominee director or a trustee, then you also have to separately comply with the requirements to tell the SEC who your beneficial owner is. So that's the way they're doing it. So it's twofold.
Interesting. Thank you very much. And with respect to trusts, are there any particular requirements, or is it mainly focused on corporations at this point?
It is, I think there are really rules on trust, or I'll have to check that, because this covers all corporations that are within the jurisdiction of the SEC, and that would of course include nonprofits. Here in the Philippines, usually business is done through a corporation, whether stock or non-stock, or through a single individual, or through a partnership. Now, we don't really have that separate trust concept that you have, I think, in the other jurisdictions. So if it's a trust, it's either the trustee is probably an individual, or it could be a corporation that holds a trust license. So I think there are certain exceptions for those who are engaged in financing, but it's only with respect to the financial instruments that they own. I'll have to check that if there's anything relating to trust, but I do know that there are rules relating to non-stock, non-profit entities, which would also require them to disclose the beneficial owners.
Okay, that's wonderful. Thanks. Thanks very much, Karina. I think Marcelo, you might be unmuted. Did you want to add something? Yeah.
Yes, in Uruguay, for example, we all the corporations that are incorporated in all entities, not only corporations, sorry, all the entities that are incorporated or domiciled in Uruguay are obliged to inform and register its full chain of ownership until the beneficial owners before the Central Bank of Uruguay. But this information is not public available. It can be used only by the tax authority for two purposes: to carry out internal audits, or in order to comply with treaties of exchange of information. And also, sorry, I didn't mention, and also the non-resident entities that performs activities in our country through a permanent establishment. And this rule has almost no exceptions. I mean, it's a very broad rule, but with a very limited use, let's say. I mean, the information, the use of the information is very limited.
Well, thank you very much for that. No, that's quite interesting. And so, is there any discussion of making any of this public over time? And I guess my other question would be, how long have these rules been in place? Because I know, as was the case with India, it seems like our rules in Canada have been around for maybe 3 or 4 years now, and they're getting stricter and stricter and more public. And I'm wondering if that trend is also occurring elsewhere.
In Uruguay, for example, since 2000, for the last 9 years.
Thank you. And I saw Bach joined us as well. Nice to see you, Bach, again. Good evening.
Hey, hi, everyone. Sorry I was late.
No, it's okay. Wonderful. I think Federico, you wanted to mention something.
Argentina has more or less the same approach that Uruguay has. There is a lot of information required by the authorities. The effort to learn about the beneficial owner started by the tax authorities, followed by the anti-money laundering authority. Then later, kind of 5 years ago, the corporate authority started to ask for that information also, not through the law, but from regulations from the corporate authority. And that information has been sparsely complied with and sparsely enforced by the authority. In the last, during the pandemic, the last couple of years, they started to enforce it by blocking other requirements that other requests that the company made unless they have filed for that information. So they are gathering a lot of information. They are not doing anything with that yet. And usually in Argentina, that information will not be public. I don't know if for privacy concerns, which are there for the private sector, but because the public authorities don't like to share the information with the public unless they are somehow forced to by the law or by international trends. So there is a lot of information in the public databases which is not accessible for the public. It is accessible for all the government. They may have some concerns about internal secrets. For example, the tax secret does not allow the tax authorities to share that information with other agencies. I know that there has been some struggle a few years ago between the tax agency and the anti-money laundering agency because they couldn't share information. I know that there was a regulation that somehow fixed that, not completely, but there are some information sharing. They classify what is completely subject to tax secret and what is not shared there. They kind of somehow ranked the information, but there is a lot of problems sharing and therefore the information and therefore enforcing the regulations. I think that is something that is going to move forward. We will have some stricter enforcement, but as Argentina has usually a 5-year study of regulations, you will learn about that 5 years after the date because they are not on top of the ball. you will have the problems you have now will be summaries or whatever 5 years down the road.
And at that point, maybe the problems have been solved or they've otherwise been dealt with. It's interesting. We see similar trends here. Sometimes there are issues that we hear about now that are actually quite old. Thank you very much for that. So I don't know, Bach, I know you joined a bit late. I don't know if you had anything to add. We were just talking about the corporate transparency rules. You and I had this brief discussion a couple of weeks ago on this as well. We were going country by country to hear a little bit more about how the corporate transparency regimes worked. So I don't know if if you had anything to add for Singapore.
Yeah, on the Singapore side, we started this need to disclose the ultimate beneficial ownership of companies maybe about only 2 years ago, quite late in the day, and it's a private registry kept only by the company secretary, and the only persons that will have access to it is the government entities, our company registration entity. They haven't mentioned tax yet, but I wouldn't put it beyond them to be extended to the tax authorities quite soon. So what it means for Singapore is that in terms of transparency, that there is nothing that we can do in relation to the government wanting to know who is the UBO. Tax-wise, UBO-wise, the declaration, that there's full transparency on that. But that there is still quite a lot of clients who are interested in using nominee and using this kind of proxy arrangement. And a lot of times it's very popular with high net worth individual. If they're high net worth, they're high profile, they don't want their names splattered in all the public documents. So we still do a fair bit of this nominee arrangement for this sort of people. So the acceptance is that, look, you get your privacy, but nothing will be shielded from the government in terms of tax, in terms of disclosure. I was wondering for the rest of the countries, what is the worst that it can get to in terms of escalation? If more and more information goes out to the public, what do you think is the worst consequences that we can look to?
I mean, at least in the Indian context, we would be worried about security, right? Because there would always be concerns about people getting access to the data and misusing it in some manner. Particularly considering how widespread inequality is, and you know how feasible it would be for someone to manipulate the system if they wanted to. So I think that tends to be the biggest concern, and I guess that's where we've really been struggling with. So going back to the privacy point that John raised, I think if the court were to make an exception to the general requirement of privacy, we would need to make a strong case to demonstrate that the security concerns or the money laundering concerns would outweigh the personal safety and privacy concerns of these individuals. And I don't think that would necessarily be a straightforward argument to make in all situations. I mean, if it's somebody who's engaged in an illegal business, then maybe yes. But if it's somebody who's a taxpayer and who just happens to be wealthier than other people, then I don't know if the court would be convinced that their right to keep that information from other people should necessarily be taken away.
Our courts have issued very strong statements to say that high net worth individuals, rich people, famous people will not be treated differently from the ordinary folks. So this was in relation to reported case authorities. We had this practice where if you are a litigant, your name will be reported in all the case authorities, and this case authorities in Singapore is made public. It's actually public document. You can Google the case and you can find it. So when we have trust litigation, we sometimes have family disputes, litigation. There will always be litigants who try to apply for the anonymization of the names. Right, so instead of saying it's this family against this family, it will be ABC versus DEF, that kind of thing. But so far the courts have taken the position that unless there's a public policy reason, there's major security concern, just because you are rich and people are curious about you, it's not good enough reason to anonymize. So I can kind of empathize with what you will have in India.
Yeah, I think there will be great concerns in Malaysia because we have personal data legislation, but it doesn't apply to government. So can you imagine the government getting all this data? And we were also involved in a recent case where our tax authorities went to our client, and client had like a membership program, they have customers and they have this reward program. And the tax authorities were asking for this data, not about our client, which is a corporation, but about their customers who are individuals. And that's to increase their database, the tax profile for their tax database. So that's really quite scary. And I think the most scary part is the tax authorities tried to compel the client to release the information, but client used personal data as a defense, as a restriction that I can't disclose because it's not my personal data, and I think that's valid. But then the tax authorities sought the opinion of the Personal Data Protection Commissioner, and guess what? They said, oh yes, you can disclose. So that's really hardly any comfort to individuals in Malaysia. So I think that's why we are litigating that case. And at the High Court level, it's been held in favor of the client, and there's a stay order against releasing the information to the tax authorities. But I think it's this kind of information which has to be vigorously, and this kind of tactics that have to be vigorously challenged and fought against. Yeah.
Well, certainly from a Canadian perspective, and just to maybe pick up on what Irene and others have said in terms of, certainly I think Baca also mentioned security, and I think from a Canadian perspective, our courts have been equally reluctant to extend particular treatment to wealthy individuals simply on security concerns. I can think of one example, in fact, a case that our firm worked on, and it's a rather unfortunate case, but there were two billionaires, wealthy billionaires, a married couple in Toronto, who were unfortunately murdered in a rather gruesome fashion, and as part of the whole estate wind up. So their estates were actually quite complex, and there were some in Canada, estate wind up can actually be public proceedings, particularly where a court has to intervene and adjudicate various matters. And so it was a public proceeding, and we've got an open court system in Canada, as many of their jurisdictions do. And so you had reporters in there listening into some very detailed financial and personal information with respect to this couple who, as I mentioned, had been the subject of a very serious crime, and other members of the family who were concerned about being also in that same situation applied to the court to actually have publication bans and confidentiality orders and sealing orders, and the case went up to the Supreme Court of Canada, notwithstanding the obvious danger to the family. The court said that the open court system, the general interest of the public to have access to this type of information to the extent it's in the public record, or generally should be in the public record, was not overcome by the personal security concerns or the personal privacy concerns of these individuals, notwithstanding the fact, as I mentioned, there were obvious security concerns for these people. So the strength of the presumption in favor of open access in Canada is rather almost absolute, I would say. So I don't know if anyone else has any thoughts. The other point, and I wrote it down a bit earlier because I know a couple of people mentioned nominee arrangements and corporations being used for nominee purposes, and that's something that I think under our corporate transparency rules would be addressed. But we've also got separate rules that actually go further. We actually have rules now in both federally and at the provincial level in Canada where nominee or bare trust arrangements need to be disclosed to the government regardless of what it pertains to. So it's not simply questions of nominee directors or nominee shareholders. There could be nominee land arrangements, right, where someone owns a piece of land or on title on behalf of someone else. There could be commercial arrangements where nominees are used. All of those need to be disclosed to the government as well. As it today, it's not a public disclosure requirement. In other words, it's just for government consumption. But again, looking at the trend that we saw with the corporate transparency rules, we're starting to wonder whether all nominee arrangements will eventually be public, such that there's no real need to have any nominee arrangements at all, because what's the point if everybody knows exactly who's up to what? So that's an interesting trend that we've seen in Canada as well. Not sure if that's consistent with anyone else's experience.
Well, here in the Philippines, we still don't have that disclosure requirement, but it would be very sensitive because we also have nationality requirements with certain industries. And of course, you know that people put nominee arrangements in place where the immediate or at least the visible owner is someone who's a Philippine national, perhaps, right? And holding it in trust for someone who's not qualified to engage in that in that business. So I think in addition to the privacy issues, that's something also that will have to be considered by people going in through these nominee arrangements. As a matter of fact, when we were discussing this corporate transparency requirements imposed by the Securities and Exchange Commission, we noted that they were saying that the company should not be used for illicit activities and all that. But we were also thinking that that's a way for the SEC to find out who the beneficial owner is and who controls this company. And they would know actually by way of the disclosure whether or not that company really is a Philippine national, if it is required to be a Philippine national under Philippine law. And I think I did not mention it earlier, but when you do the look through, I think like most jurisdictions, we also end up with the ultimate individual. It's a natural person who has to be reported there in our general information sheet. And in this respect, aside from the privacy, we've had clients who were very concerned about it. They are not Filipinos, so that they're outside the Philippines, and they really didn't want their details because the detail you're required to put in your passport number, tax identification number, stuff like that. That all has to go into the general information sheet, and they were very worried, especially if it could be searchable, because it may be searchable not only in the Philippines but also outside the Philippines, and they had security concerns about that. So yeah, it's interesting. I don't know if nominee arrangements will ultimately be required to be disclosed, but I just don't know also how they will be enforcing it.
Yeah, that's. Oh, sorry. Go ahead, Bak. Yeah, go ahead, please.
Then I was just wondering, when you say that you're required to disclose the nominee or the bare trust arrangement, that does it mean that the relevant government authority or the law doesn't recognize the bare trust? As in, they will look through the trust, look through the nominee arrangement, and look to the ultimate beneficiary. Is that the consequence of it?
Are you asking about the requirement to disclose in the reports to the Securities and Exchange Commission? Well, insofar as the nominee arrangements are concerned.
Yeah.
Oh, okay. Because of certain rules in the Philippines where it's let's say for certain industries there's a required nationality ownership. Let's say for land ownership, so 60%, or a company that owns land should be owned at least 60% by Philippine nationals. So when we say 60%, that's both legal ownership as well as beneficial ownership. So that's where your nominee arrangement would go.
I see.
Yeah, and I think what related to that is in Malaysia, this kind of nominee relationships are also quite common because of those requirement to have local shareholding, etc. So, but if it's, for instance, a foreign investment committee requirement that you have to, and actually it's held by the nominee who is not a particular nationality, etc. Then the question is, how can you sue each other if they don't honor the trust? And the courts will not help you to enforce that because it's against public policy. So that's the risk as well. And I think in some cases, what has been done is they'll ask if you have a nominee shareholder, that you want the COSAC company secretary to record that it's held on trust for whoever is the beneficial owner.
Right.
The reason why I asked is this, John, sorry.
Sure.
In Singapore, we do use nominee arrangements and we do use bare trust. So we have certain legislation like what you have in Malaysia, Irene, where it states clearly that the nominee arrangement will not be allowed. It will not help you overcome the restrictions. So for instance, our Residential Properties Act, it's got to be owned by Singaporean. So you can't have a nominee arrangement where the Singaporean holds it on trust or as a nominee for foreigner. But on the other hand, in relation to our very high and expensive stamp duties for buying properties in Singapore, the authorities do allow a bare trust arrangement. So we will have parents buying property on trust for their 3-year-old son, and the 3-year-old son supposedly as the ultimate beneficial ownership. And this sort of bare trust arrangement is allowed, and it is possible to use it to overcome the high stamp duties that we have in Singapore. So we seem to have these two different paths in relation to how we treat this nominee arrangement. And I was just wondering also, because John, when you said that in Canada, the bare trust and nominee arrangement has to be disclosed. And I was wondering, when you do disclose it, does it mean that your courts and the legislation then do not recognize the bare trust or the nominee arrangement and will look right through to the ultimate beneficial owner?
Yeah, so I understood that question before. So I think the nominee and bare trust arrangements are recognized for Canadian law for pretty much for all purposes. If I look specifically for tax purposes, where some of these rules are particularly relevant, the beneficial owner for Canadian tax purposes is the one that has the tax obligation. And so I think what our tax authorities had been seeing over the last decades until the last few years when they started to come up with these rules was that people were picking and choosing. So for example, you might have a situation where, let's just take a simple situation, shares are registered in the name of an individual. And then when let's say the shares of a company, the individual owns this company and then decides he wants to sell the company. And then all of a sudden starts to suggest, well, actually the shares were being held by him on behalf of his children or on behalf of other individuals, so that the tax obligation either gets split up or otherwise reduced or otherwise dealt with in a way that that might not have been consistent with reality. So what the purpose of these new nominee disclosure arrangements, disclosure rules are actually intended to allow the tax authorities to always be aware at the time a nominee arrangement is entered into. So every time you enter into a nominee arrangement, you have to disclose that the existence of that arrangement to the tax authorities, so the tax authorities now know who is the nominee, who is the principal, who's the agent, and that information can't then change later on, because there's a presumption that if the nominee arrangement wasn't disclosed, that it didn't exist. And if it's disclosed late, there are actually rather hefty penalties that apply to it. So it's a real incentive for people to actually make full disclosure of these bare trust or nominee arrangements upfront, so they can't have the ability later on to change the facts as it might suit them in order to, for example, reduce their tax liability. So that, I think, is the real thrust of the rules and why they were entered into. But yes, to answer your question, nominee arrangements and bare trusts are recognized at Canadian law across the board. It's just a question of making sure that the facts actually align with the arrangements that are claimed to be bare trust or nominees later on. So I don't know if anyone else had anything else to add on this topic. I think it's interesting personally from my perspective. I'm looking at every other jurisdiction that we've heard from today, and nobody seems to have public registries. So it's interesting. I'm actually part of a working group that's making representations on behalf of the Law Society in my region to our various governments, actually arguing against further public disclosure for reasons related to privacy. And I'm very heartened to know that most other jurisdictions seem to have those same concerns, and that we would, in many respects, be an outlier in Canada in that respect. Although I do believe that the United Kingdom has a public registry for ultimate beneficial owners, and so that's we tend to, based on our colonial past in Canada, tend to look to the UK for inspiration from time to time, and so I'm sure our governments are going to be looking to the UK government in that regard. And And I also believe as well that certain European countries, it's actually funny, I think I was talking to Bach about this a few weeks ago, but certain European countries actually have very strong disclosure requirements, not just for ultimate beneficial owners, but I believe it's Finland requires the disclosure of tax returns, and tax returns can actually be searched as part of a public database. So that's even, I think even a further step towards transparency that I'm not sure we're quite ready for in Canada. So, and I'm sure the same would be in your jurisdiction. So.
One extra issue that may be of interest is that there is a lot of Argentinians that has companies, LLCs in the US, and are holding assets or doing business through that companies into Argentina. Argentina has requested the US to share the information about who those beneficial owners are of those companies. And at least for a few years, the US has refused on the grounds that they don't have that information. They don't request for that information, and therefore don't have it, can't share it. There have been a couple of high-profile cases in which, after through investigation, it was known that certain local individuals were hidden behind those companies. So at some point, now it's not in the newspapers, but at some point it was a request for making a stronger request for that. I have not been following the issue, but I don't think that it will stay as it is. From what I heard, the US is already gathering some kind of that information. By the US, I would say it's a state issue, not a federal issue. So it may change from state to state, and it's not my field of practice. But I do expect to see changes there in the future. I don't know if the near future, but it's at some point that will happen. So just pointed out that there is a major jurisdiction where a lot of companies using a lot of people is using companies as tools to shield their privacy, and that may change in the near future. It was an issue with Argentina and Uruguay, and as Marcelo said, Uruguay started to gather the information after, I would say, kind of a decade of discussion between Argentina and Uruguay of what information should be provided. Of course, there is a size issue between the countries. Nowadays, it's Argentina the one asking the US, and there is also the reverse issue regarding sizes, but I don't think Argentina is the only one asking that information from the US.
Certainly, I hear what you're saying, Federico. Certainly, in my practice, we often have similar questions coming from the Canadian side to the American side for information pertaining to LLCs. And I take your point. The U.S. has a similar, I guess, federal structure as Canada, is that most of these decisions tend to be made at the local or regional level, at the state level in the US. And so it becomes quite difficult and unwieldy to coordinate among 50 different states. And for various political reasons, you've got states that that don't necessarily want to go in the same direction. Whereas I think Canada has a similar federal structure, but we I think have less of a politicized environment. So I think most regions and most provinces in Canada tend to adopt the same rules, but we're having very difficult discussions or situations with American transparency requirements depending on which state you operate in. You can be in New York and have completely different requirements than if you're in Texas or elsewhere. So it's quite remarkable.
Mm-hmm.
John, and going back to your comment about the discussion that is being carried out in Canada about the possibility to register your tax returns. In Uruguay, there is no obligation to inform or to register your source statements, your fiscal source statement, but all the companies that have asset exceeding 1 million and or income exceeding 3 million have the obligation to register its full financial statement before the internal bureau. And this information can be searched, I mean, it's public, but the one searching the information has to pay a fee to the state in order to access the information. But you can only search for specific companies. I mean, for example, if yes, go ahead. Sorry, you were, some of you were raising your hands.
No, we saw a little note from Shreya from India who mentioned that she had to drop off but wanted to say goodbye to us. So we were just waiting.
Okay, sorry.
Sorry, didn't mean to interrupt.
No. Yeah, you didn't interrupt. I end my comment.
Okay, well that is I think it's good and interesting to know. I know in Canada I think we've got similar requirements too for larger companies to disclose certain financial information that is searchable. So I think that's that's something that I've seen as well. And I think in those contexts too, I think we do have a public registry, but the public registry in many cases has a fee associated with it. So it's quite similar to what you were describing, Marcelo. So I don't know if anyone else has any thoughts. I mean, we could also we've got a few minutes left before the meeting wraps up. Hannah, perhaps we can have a discussion about future topics. I thought this one was interesting. I think it would be neat to hear what other topics we might hear about for upcoming meetings.
Yeah, I think that's great. If somebody has any ideas or if there's something you think is interesting that you want to share with the group or that you want to hear from others that you've read about that maybe you want us to do a little digging and see if we can find someone to speak on, definitely happy to facilitate that. Does anyone have any thoughts?
I would be delighted to hear about a special regime for foreign investment. I mean, Argentina has very stringent regulations about that, and I would love to compare what we have against what there is available in other portion of the world. What I usually work with is I'm focused. I am a tax lawyer, and my key focus is on the mining industry. So I'm very, and I am aware of the regimes that are available regarding mining investment in South America. Because I was a regional tax director for a multinational company, and then because my clients have operations in Argentina and other countries in South America, which I compare and see what they are doing. But I don't know what's going on in other parts of the world regarding those issues. So I would be delighted to hear that about that if is of interest for the group.
I think that's a very thoughtful suggestion. So I think we should add that to our list. And I could also send you some materials. Obviously, Canada has a rather robust mining regime. Yes. As well. So maybe I can send you some information too about some of the incentives we see throughout my country, and maybe that might be of interest to you.
Well, indeed, I was working for a Canadian multinational, so
that's right. I think you mentioned that.
Yeah, I'm a bit aware about that, but
it would be
Which
great
one?
to catch up. Barrick.
Barrick Gold, that's what I thought. Yeah, I remember we had a discussion maybe about a year ago about that. Yeah, Barrick, that's right. Excellent. Any other thoughts on potential topics? I know that this group is both tax and wealth management, so there's also the aspect of private client work and ultra high net worth individuals. I know Bach had some thoughts that we discussed a few weeks ago. Interplay between marital law and inheritance law. I think there were some other topics that people wanted to raise too.
Yeah. Something that comes to mind is, and it's purely because it's pretty hot topic now, cryptocurrency. But I guess it depends on whether there's interest in that.
Me
Yeah.
too. I am interested in the same topics as Irene.
That's great. I like that topic too. I've done some research quite a bit over the last few years. So I think that's a real hot topic around the world. So that's something we should probably add to our list.
I'm also very interested in learning about it. John and Bach, I think that's all
Sure.
on my end. I don't think we had anything that we needed to touch on, but the three of us, of course, will meet. I am remiss in introducing Alyssa. I forgot that Bach and John met Alyssa, but Alyssa joined us a few weeks ago as our marketing and communications coordinator. So she'll be working really closely with me on the practice and industry groups, and you'll see her at future meetings of this group and any others that you're part of going forward.
Yes, nice to meet you all, and thank you for letting me sit on. And it was really interesting to hear all your points on the discussion.